Although no trust was properly established and assets cannot otherwise be transferred to beneficiaries, clients sometimes wonder if there's a way for them to avoid a long and expensive probate. And in fact, in limited circumstances, there is one way to avoid a probate. That is to say, you might be able to avoid probate if you are the decedent's surviving spouse or domestic partner. You see, after the death of your spouse or registered domestic partner, you might be able to avoid a probate with a mini court proceeding known as a spousal property petition. There are two main benefits to this petition over probate. First, the whole process can be completed in about a month, so it's way quicker than a probate. And second, legal fees are generally much less than if a probate was completed. Most of the time, though, the facts and circumstances of a case must be pretty cut and dry for a court to grant a spousal property order. Also, you should bear in mind where a conflict does arise, a probate may still need to be open. Anyhow, when a spousal property petition is being considered, attorneys will generally look to see whether there is a will or not, whether the property that needs to be transferred is community or separate property, and whether or not the surviving spouse or domestic partner is the only beneficiary. If there is a will that leaves all the decedent's property to the surviving spouse or domestic partner, both the community property and separate property interests of the decedent can be transferred by way of a spousal property petition. The way this is done is that the surviving spouse or domestic partner petitions the court to confirm both the survivor's one-half interest in his or her own community property, as well as to transfer the deceased spouse's or partner's interest in their separate and community property. In other words, the surviving spouse or domestic partner is simply asking the court to transfer all the couple's assets to them. If there is no will, and the surviving spouse or partner is the only beneficiary as outlined under California's intestate succession laws, the same rules and procedures apply. But if there are other beneficiaries, the situation becomes a bit more complicated. Please see the video on intestate succession for more on who will be entitled to take a share in these cases. Generally speaking, though, community property assets may still be confirmed and transferred to the surviving spouse or domestic partner. If there are other beneficiaries, however, separate property will be split between the surviving spouse or partner and the other beneficiaries entitled to a share. All told, spousal property petitions provide a handy way to transfer title and ownership of property to a surviving spouse or domestic partner without enduring a long and expensive probate. To find out more, please schedule a free appointment here at the Trust Store.